We're going to do another practice question. This is another torts question, and it could be used to practice for the California bar or another bar in the United States. It's a 1L subject, and so we're going to go ahead and read the question now. I put up some graphics for you just to help you picture it. And the way this works is I read the question, I give you the 4 choices, and then I pause for a second, and then I tell the answer, the best answer. And so you can pause it if you need a moment to think about it before you answer. And then I also am doing supplemental Emerson Bar Review videos and expanding on the law with respect to that. So you can get a better feel for the law in the United States in general and California. Of course, check the rules because they change from time to time, but this is the general rule, okay? So this is question number 13. Owner owned a house in city. By the way, I'll put the link to the PDF that has the answer key and all the questions in it if you want to print it up and practice it, or just practice it online. And so here we go. A storm sewer owned and operated by city ran under part of owner's house. Water from the sewer main escaped into the basement of owner's house, flooding the basement and causing substantial damage. The jurisdiction in which the city is located has abolished governmental tort immunity. If owner asserts a claim against city, the basis on which the owner is most likely to prevail is A, negligence if the sewer main was improperly constructed and maintained, or B, strict liability because the water escaped from the city's sewer main, or C, strict liability in tort if the sewer main was defective, or D, nuisance because the owner's used enjoyment of his house was interfered with. Go ahead and pause it if you haven't answered it yet. I'm going to go on to the answer. And drum roll, please. The answer is A. This is a landowner-homeowner question asking in what type of tort claim might the homeowner most likely prevail in court against the city. A lot of people take property law the first year of law school, and there's, that bundle of rights that you have to enjoyment. But in this case, it's a public water sewage drain utility that has failed, and it's a matter of common usage under the balancing utility versus risk. The governmental immunities abolished in this case. And if you look at Rylands versus Fletcher, that was a strict liability for an ultra-hazardous activity that was discussed under restatement. There's 6 factors in determining if it's ultra-hazardous, abnormally dangerous. There's is there a normally high risk of harm? What's the gravity of the risk? Can the risk be eliminated through reasonable measures? Is the activity commonly used? Is the activity appropriate where it's being conducted? How well is the activity benefiting the community? So this is explaining why the other ones are. So basically, A, negligence if the sewer main was improperly constructed or maintained. The reason it's not nuisance or strict liability, I was kind of elaborating on. So that was the best way that the owner would prevail. Thank you for listening. I could go on more about this, but I think basically in this case it's not a strict liability because it's not really a ultra hazardous activity, because it's a utility. And there's other videos on here that explain how In tort, there's the utility, the balancing when you're deciding if it's ultra hazardous or abnormally dangerous, and the sewer really, is not abnormally dangerous. It's utility. It's the gravity of the risk. It can be eliminated through reasonable measures. Is it commonly used? Yes, it's commonly used. Is the activity appropriate where it's being conducted? Yes. How well is the activity benefiting the community? That is why it's negligence. And the Rylance versus Fletcher case, you might have thought of that if you chose the other one. It's because back then, that was being used in two businesses, and it wasn't something normal, it was abnormal. So when you're looking at what you're suing for in tort, you have to look at the nuances that might not be so obvious. Now, this might trick somebody, the D, because, you think about property law and you think about the bundle of rights to enjoyment, but this is not somebody getting, it has to be non-trespassory, like, it can't be trespassory. So, that's why it's not D. All right, so thank you for listening. I'll go on to the next one.